Now, I have a happy task today because we, as a profession, we face the most extraordinary challenges, and we do live in a diminished time when we are seeing that access to justice is being rationed, and of course the first casualty are the vulnerable. But I have some good news, and you're going to hear today, for the first time, only here, that major reform to third-party motor insurance is in the offing. It is a certainty. It's probably too early in the morning for the civil service to be actually working on the redrafting just as I speak. But almost literally, the Road Traffic Act, Part 6, which deals with the third-party motor insurance requirement, is being redrafted. And also, two of the most offensive documents ever devised, supposedly to protect vulnerable victims of other people's folly, the uninsured drivers agreement and the untraced drivers agreement, those two documents are also being reviewed. In fact, more than reviewed, they will be changed, and there are drafts already being circulated. This is extremely good news, and I want to explain a little bit the context of this. Now, I have, you're not going to get slides from me, but what I have produced for you is a paper. It's in your pack. I'm afraid it's not as exciting as a lot of the goodies next door, but what it does is it explains the whole rationale behind third-party motor insurance. It's not about charity, it's about common sense. Back in 1930 was the realization with the cheap production of cars like the Austin Baby, which rolled out in 1922 for a price of £400. No longer was motor ownership the preserve of the rich, but in fact it was becoming readily affordable to a large section of the public. And with that came the risk to members of the public that if they were injured by what is a very dangerous machine, they could face the fact that they have a Pyrrhic victory in that they are awarded damages which they cannot hope to recover from the driver because the driver does not have sufficient means. So it was a result of this realization and the state not wanting to burden itself with social care for critically injured people as a result of this growing use of motor vehicles, that the first Road Traffic Act, well, the 1930s Road Traffic Act introduced for the first time the concept of compulsory third-party insurance. Sensibly, the government looked to the private sector to provide a solution. It was already there. Motor insurers were providing motor insurance for the very rich who could own the luxury cars. What this legislation did was to compel anybody who used a motor vehicle on a road to purchase this new product, third-party motor insurance, to ensure that there was at least sufficient means with which to compensate a victim injured as a result of the use of that vehicle. It created instantly an artificial market, a captive market. Which one of us wouldn't like to know that our clients were obliged by law to consult us every year and that we could just set the price? Well, that's exactly what happened with motor insurance. It's a captive market. It's very cosy. And a nascent sector has now grown to a multi-billion-pound industry. Governments come and go, but the ABI and the Motor Insurance Bureau, whose board is made up of all the senior executives of the motor insurance companies that profit from this market, they remain, and it's become a very potent force. We need motor insurance. They do a very good job in, how can I put it, in the round, but they are a commercial organization, they are commercial companies. Their interest is to earn profit for their shareholders. They should be recognized as such. My worry, my growing concern over the years has been that there's not a sufficient recognition of this really rather unconstitutional effect that motor insurers enjoy over government. We saw an image of the man whom many of us love to hate Sir Rupert Jackson, but just let's remember that Sir Rupert Jackson didn't actually fix the fixed costs to their present parlous level. That was something that was agreed by government and the insurance industry in a cabal, in an agreement, which we were not invited to, I suspect because the Ministry of Justice knew that we would win the arguments as practitioners. There are all sorts of other benefits which the motor insurance industry have managed to negotiate in their favour. For example, the fudge over the discount rate. This is stealing money from the vulnerable. For 8 or more years, the discount rate has been set at such a low level. This is a very sensible measure in principle. It's designed to make a reduction to the amount of compensation that's awarded to a victim for long-term care to take account of the amount of money that can be sensibly invested and received by that investment on that capital sum, so that they're not overcompensated. But the amount that's deducted assumes a much greater earning potential than actual in reality exists. It's been known, it's so obvious, yet we're still facing really quite disingenuous behaviour from the Ministry of Justice. And it's tragic, and I know where this all comes from. Now, returning to the topic of motor insurance, there was this simple idea of third-party motor insurance. But within the first 4 years, it was clear that the motor insurers weren't playing game. They weren't paying out on judgments, they weren't satisfying judgments, and they were raising all sorts of exclusions and exceptions, so that the policies that they were writing were simply not worth the paper they were written on. So they were getting the premiums, but not paying out the compensation. So there was an eminent report by Sir Felix Cassel in 1937, whose committee investigated the whole issue, and he made recommendations, which was that motor insurers should not be allowed to rely on contractual exclusions of liability or limitations in the contract as against a third party. Why? Because the whole concept of third-party motor insurance is not about protecting the interests of motor insurers, save, obviously, not to abuse the position so that they are in a position to operate a business, nor does it look really to protect the policyholder. It's not about protecting the careless driver from being made bankrupt. It's about ensuring this common sense policy of ensuring that the victim actually recovers the compensation to which they're entitled. If the victim was largely at fault, then of course the damages will be reduced and the insurer doesn't have to pay out. It's not a no-fault compensation regime. But along the road from 1930 to the present of 84 years, there have been so many exclusions and restrictions prevailed upon by various amendments to the Road Traffic Acts, bolted on without any real appreciation as to the effect that they had to the main body and the main principle underlying the Road Traffic Act, that we now have a very flawed regime. And I explain this in my paper. And we've got to the stage in 2012 in a case called EUI against Bristol Alliance Partnership, where Lord Justice Ward, in a meticulous judgment, which was, in my opinion, far too doctrinaire, came to the bizarre conclusion that under the Road Traffic Act, we as road users have a duty to ensure that we take out motor insurance that covers every use we make of our motor vehicle, but, and this is the big but, there is no corresponding duty on the motor insurers operating in this captive market to provide us with that product. How daft is that? And this was a case where a man was so distressed and unhappy, he wanted to commit suicide, and he used his car to do it, and he drove it down the M32 into the prestigious new House of Fraser store. Mercifully, he survived. He badly injured another driver who happened to be parked nearby. But the insurers in that case, the motor insurers, were able to argue that their policy excluded deliberate damage. Well, that may be perfectly proper to do in any contract between an insurer and a policyholder, but where in my view, Lord Justice Ward went wrong was saying that that breach of contract relieved the third-party motor insurer from having to pay out to the victims involved in that accident, and in fact treating the case as an uninsured driver case. And then it was dealt with under the uninsured drivers scheme, this catch-all arrangement, agreed between the Secretary of State for Transport and the motor insurance industry. And surprise, surprise, it came foul of one of their exclusions of liability, and therefore the claim failed. But the good news I have comes from two cases, both considering European law, and that's the crucial issue here, European law. One is a case that comes from a reference from the Slovenian government to the Court of Justice in Europe. Another, the second case is a Court of Appeal decision in Delaney, which was announced on Monday, delivered on Monday, and in the case of Delaney against Secretary of State for Transport. What's interesting is this. It's European law that is providing us with a fair solution for our clients, because, ironically, the European motor insurance directives are closer to the principle originally envisaged by our Parliament back in 1930 than our current hodgepodge of mixture of legislation and extra statutory provision that is the uninsured and untraced drivers agreements. Why? Because in 1972, the first motor insurance directive required users of motor vehicles to have third-party or to have insurance cover. And the idea is obvious, the reasoning behind this, that if we are to encourage free movement of people and vehicles throughout then it was called the community, there should be certainty that if somebody is injured by, whilst travelling abroad in the European community, or now the Union, that they should at least have a comparable system of compensatory protection. What happened was that, that the European legislature and the European Court is far more independent from, of the influence which is exerted in this jurisdiction by the motor insurance industry. And as a result, whilst our provision for motor accident victims has been getting more and more circumspect, more and more restrictive, more and more constrained, on the continent, it's going the opposite way. And there were three directives, first in 72, next, second one in 1984, and then in 1990, that tightened up the provision and restricted the wriggle room of individual member states to allow exceptions and exclusions. So, in essence, what the motor insurance directives now require member states to provide is compulsory third-party motor insurance that is good for and fit for purpose, so that if there is some motor insurance in place on the vehicle, as far as the victim is concerned, it is good for whatever use has been made. Insurers enjoy a special market. This is the quid pro quo of operating in that captive market. And first case is an extraordinary case, Vnuk. It was announced in September. I was the very first person in this country to know about this decision. It was most exciting. It involved nothing to do with roads. Clear your mind of roads, bridges, car parks. Think instead of a bucolic scene, a farmyard in Slovenia, in the dog days of the harvest, in, I think it was August. A farm worker up a ladder was knocked over by a trailer reversing with the bales of hay. And he sued the driver of the tractor for his injury, and the matter was referred to Europe. Should this be covered by the third-party motor insurance? It didn't involve a road. It was nowhere near a road. And after all, the tractor was being used as a machine, not as a means of transport from one location to another. The European Court found this very difficult to decide, not least because there were differences in language between the French, English, and German versions of the directives. So it had to look at the main policy underlying the motor insurance requirement. And it was this. It said, basically, Of equal importance to free movement of travel is the protective purpose of protecting victims. It's so important that we cannot allow member states to have all sorts of different exclusions and exceptions, and therefore it must be covered. So provided there is some motor insurance in place on a vehicle, it must cover any use of that vehicle at any location, whether on private land or public land. Now, we know under the Road Traffic Act that there are a whole host of technical and geographical restrictions to the duty to insure and the scope of motor insurance. Now, it just doesn't make sense in a modern day where there's four-wheel driving, where the motor cars are used off-road and on-road. Why should a child knocked down on somebody's driveway immediately adjacent to a highway be excluded from compensatory cover for that vehicle that has insurance when they would be able to recover a few feet standing on the pavement adjacent to the road? It doesn't make any logical sense. And so VNUC is going to result in a major rewriting of the Road Traffic Act. Furthermore, the second case I wanted to share with you, the one that came out on Monday, it involves a very unappealing claimant. But for goodness sakes, we've got to understand that there's no such thing as the deserving claimant. They are citizens who are entitled to the rights of a citizen. And if a citizen is injured as a result of somebody else's carelessness and they are not at fault for themselves, then they should be compensated. It matters not that this particular individual happened to be a drug dealer. Yes, he's a horrible individual, but he was injured by somebody's negligence, completely unconnected with his habit of smoking cannabis or dealing in it, and he was entitled to compensation. The matter was very complicated. I won't go into details other than to say it ended up being treated as an uninsured driver's case. The MIB excluded liability because the driver must have known the vehicle was being used for a criminal purpose, because it has this exclusion in Clause 6. The criminal purpose being drug dealing, and therefore it refused liability. The matter went to the High Court, then the Court of Appeal, and amazingly, not the solicitors, nor the QCs involved, nor the three Lords Justices of Appeal thought to ask whether the MIB's exclusion of liability actually was consistent with European law. The case was thrown out wrongly by the Court of Appeal, and I wrote a rather opinionated piece. Very shortly after that, there was then an action against the Secretary of State for failing to enact the proper law for allowing this exclusion clause. This was upheld by that brilliant man, Mr. Justice Jay, at first instance, and now unanimously on Monday by the Court of Appeal. Now, what's terribly important about Delaney is not this rascal, not this particular exclusion, but the Court of Appeal have said the writing for the government was on the wall from 1996. It was clear from 1996, a case called Bernaldez from the European Court of Justice that said that there is no discretion of member states to introduce exclusions of liability, whether under the Road Traffic Act, the primary liability to insure, or in the safety measures operated in this jurisdiction by the MIB. This means that a whole load of vicious strikeout clauses, a whole load of exclusions of liability, such as the MIB's exclusion of subrogated liability, such as the way the MIB abrogates to itself the right to deduct compensation received by a victim from other sources so as to result in a net saving to the insurer. Not allowed in a normal civil action, allowed under the uninsured drivers agreement. All these things will have to change. The only thing that's uncertain about the reform that will unfold, probably this year, is the extent of it. There's a long history of the government conceding the minimum only, and I think this is primarily at the instance of the insurers who argue about the cost, and of course we have to consider the cost of premiums, and that's where we come in. If we interpret and apply our national law consistently with European law, we will be able to deliver through the courts our clients' full compensatory entitlement. It's fabulous news. It's exciting news. It means that we can really count and have some fun. Thank you very much.